Welcome to another session of SQE1 window. We are on chapter 8 of dispute resolution, looking at commencing civil proceeding, and we'll try to understand the formal process of initiating civil litigation in England and Wales. So, once again, today we will actually begin the procedural birth certificate of a claim. So to speak, under the civil procedure rules, proceedings start when the claim form is issued. But we must not confuse delivery with sealing. Delivery with the fee stops the limitation clock. So this is where limitation period is counted. Or once you have done it, limitation clock stops. While sealing, the court officially starts the proceedings. So think of it in exam question like, your limitation period is once. Claim, like, delivery of claim form with fee stops the limitation clock. So think of it as sending your application to Hogwarts. Posting the letter is not enough. You need the official owl to deliver it and get the magical seal. The choice of court also matters. County court for most civil claims and high court for heavyweight matters. The ones with more zeros or public interest. By the end of this chapter, you should be able to tell not just when a claim starts, but where it should start. Let's get to it. So, the first thing is choosing the right court. $1 million question, or £1,000,000 because we are in UK. So sometimes I go for dollars. I don't know, like it is a strong currency or not. So once again, £1,000,000 question, or sometimes $10,000 or pound questions. In which court do we choose? The county court is everywhere, like Greg's or Starbucks. There is one in every town. It deals with most routine civil cases. For money claims, you normally begin at the Civil National Business Centre, but certain cases have special homes. Probate, dispute, intellectual property, or construction claim belong to their specialist courts. If you mistakenly send a patent application or patent dispute to a small local county court, the judge might give you a look and say, "Really? You don't understand how it works?" Then we have High Court, the Rolls Royce of forums, dealing with personal injury claims over 50,000 or any other exceeding 100,000. Choosing the correct court is more than a clerical choice. It affects track allocation, costs, and whether your client's case will survive procedural scrutiny in SQE questions. Be mindful of the fact what you are choosing, which forum you are choosing, so at that point you can be tested in SQE that you got a patent claim where you will go to county court or specialist court. That's what you need to understand. So, civil procedure rules part 7 and the claim form. Let's now open the curtain on civil procedure rule. The bread and butter of civil procedure. Most proceedings begin with the form N1 claim form, and this must include key ingredients as set out in CPR 16.2. You don't need to memorize all these numbers about CPR. It will not be tested. You need the parties' details, a short statement describing the claim and remedy sought. If it's a money claim, add a statement of value under CPR 16.3. Once again, you don't need to memorize it. The statement of value hints at which track the claim will go. So small track mean under 10,000, fast track 10,000 to 25,000 pounds, multi-track anything above 25,000 pounds. For personal injury, the thresholds differ slightly. For SQE, please remember this golden rule: delivery stops limitation. sealing starts proceeding. Miss that, and the examiner will bounce. It is kind of detail that separates a near miss from a pass. Service of proceeding. So once the claim form is issued, it must be served. Of course, it must be told. And here the civil procedure rules are less forgiving than a British traffic warden. Really? We don't have British traffic warden or British traffic police and all. Usually they are discreet. So under CPR 7.5, you must serve within 4 months if the defendant is in England and Wales, and 6 months if they are living abroad. Service methods are listed like a menu: post, DX, personal delivery, or email, but only if the other side agrees. Timing is strict. The act must be completed by midnight on the final day. If you serve late, your claim may be struck out faster than a bad Tinder match. A bad kind of like Tinder match. so that is struck out, like, with false details and all. No second chance. Always note the deemed service date. For example, first class post is deemed served on the second business day. The small details are where SQE loves to test. So that's what you need to understand. Okay. The next thing is service outside the jurisdiction. Now things get slightly international. Suppose your defendant has jetted off to Paris and Dubai, or Dubai like they are living somewhere. Can you still serve them? The short answer is yes, but carefully. There are 3 main routes. First, you may serve within UK, say in Scotland or Northern Ireland, without permission under the Civil Jurisdiction and Judgment Act 1982. Second, you may serve outside UK without permission if there is a jurisdiction clause or a valid legal basis. Third, you may apply, and that's what it works most of the time, for permission under practice direction 6b. You don't need to memorize them, where there is a strong connection to England and Wales. Service abroad is procedural diplomacy. If you get it wrong, you risk wasting months and irritating foreign courts. For the SQE, remember that permission is a magic word to serving abroad. It is like a visa for your claim to travel overseas. So keep in mind, abroad, most of the time, it is permission that you need to take. So what is in particulars of claim? So it is where claimant tells their story concisely, persuasively, and with enough structure to survive cross-examination. It can appear on the back of the claim form, or as a separate document you can attach with it under CPR 16.4. You don't need to memorize. Once again, it must include the fact relied upon, the legal basis of claim, the remedy sought, and or any claim of damages or interest. You finish with a statement of truth, not optional unless you fancy an angry judge. I always tell my folks, drafting particular is like baking. Too much details, you lose the texture. Too little, and no one believes it's real. For SQE1, note the difference between claim, form contents, and particular. 2 different things. That distinction often appears in procedural question. Get it right, and I usually gain easy marks. Those are kind of like easy scores. So for SQE, you need to keep in mind, I will try to just wrap up everything. First, be crystal clear about when proceeding starts, delivery stops, limitation, sealing starts action. So, limitation is different, start is different. Second, know your jurisdiction, county court for most, high court for big leagues. Third, service time limit, 4 months here, 6 months abroad. Forget that you might as well write automatic fail in the margin. So if you forget it, believe me, Some people even forget this one as well and they confuse it. Fourth, remember when to use part 8 instead of part 7 when there is no substantial dispute of fact at that point. Common pitfall include forgetting to file the certificate of service, serving to the wrong address, and miscalculating the deemed service date. If in doubt, check the CPR twice and the calendar once. And remember, the examiner loves testing where candidate trip on deadlines. So take your time, stay calm, and treat every procedural step like you are diffusing a bomb, carefully, confidently, and with both eyes open. Only one thing I would say, all these things will look like a bit overwhelming, load of information, but if you just wave it around the story, just create a character in your mind, a fiction in your mind, and start from the very first chapter and wave it around that very person. For example, Alex, who got a problem, starts civil proceedings and start it from the first chapter all the way to the last, and you will love my advice. Thank you very much, and I hope to see you soon with another one from the dispute resolution. And once again, to reinforce or to enhance your understanding, I would advise take our notes and question banks. Thank you. Ta-da.